An advance directive is a legal document that gives guidance about the types of healthcare a patient accepts in the instance that they become unable to make their own decisions. It can also appoint another person known as a proxy to make these decisions on behalf of the patient. In this video, we'll cover when an advance directive applies, who should make an advance directive, and the 4 types of advance directives. First, let's review when an advance directive applies. Advance directives are valid in any medical setting where the healthcare provider has a record of it. A healthcare provider can only go against its orders when the decision goes against the individual healthcare provider's conscience, when the decision is against the healthcare institution's policy, or if the decision violates accepted healthcare standards. Laws about advance directives vary state by state. Some states recognize the directives of others, but not all. Advance directives can be changed or revoked by the patient at any time. Next, let's cover who should make an advance directive. Advance directives are usually used by patients suffering from terminal conditions or life-limiting illnesses from which they are unlikely to recover. It's wise to include the following details in any advance directive: care requests, body disposition, list of people not permitted to make medical decisions for the patient, name and contact information for the proxy, names and signatures of witnesses, and the signature and seal of a notary public if required by state law. When an advance directive is complete, the patient should provide copies to their doctors, proxy and alternate proxies, and any family members who they think should have one. Additionally, it's important to know the 4 types of advance directives. First, a living will explains a patient's wishes regarding end-of-life care in the instance they are too ill or injured to make their own decisions. 2 physicians have to confirm the patient's incapacitation before the medical team can resort to the living will. They often address comfort care, dialysis, IV hydration, organ and tissue donation, resuscitation measures, tube feeding, and ventilation. Second, in a medical power of attorney, a patient names an individual to be their medical decision-making proxy. The proxy is expected to make decisions based on what they believe the patient would want. In order to be a proxy, a person has to meet the state's requirements for a healthcare agent, not be on the patient's medical team, be willing to discuss end-of-life issues, be trusted to adhere to the patient's wishes, and be trusted to be the patient's advocate. Third, a do not resuscitate is a form that forbids healthcare providers from using particular life-saving resuscitation techniques on a patient. Unlike the previous versions, it must be signed by both the patient and their healthcare provider. Finally, a physician order for life-sustaining treatment, more commonly known as a POLST, lays out specific medical orders for a seriously ill patient regarding hospitalization, life support, medication, pain management, and resuscitation. It must be signed by the patient's doctor to be legally binding and is normally appropriate for patients who are in their final projected year of life, in an advanced stage of terminal illness, or are suffering from an illness or injury from which they won't recover. So there are plenty of legal documents online. If you're in need of a living will form, a medical power of attorney form, a DNR form, or any other form, we have thousands of state-specific ready-to-go templates available for you to download, all for free. Click here to get your forms instantly.